In this lesson, we will discuss the fiduciary duties an agent owes to their principal. Before getting started, let's discuss a few key terms. First, an agent refers to a real estate salesperson or broker acting in a fiduciary role on behalf of the principal. The principal refers to the seller or buyer of real property who benefits from a fiduciary relationship with a real estate salesperson or broker. The principal is an individual who hires the agent to work on their behalf. Fiduciary duties refer to the legal and ethical responsibilities an agent owes to their principal. When you, as a real estate agent or broker, act on behalf of a buyer or seller, you are bound by certain legal and ethical obligations referred to as fiduciary duties. The main thing to remember is to always act in the best interests of the client, as long as that does not mean breaking the law or acting unethically toward another party in the transaction. For example, Realtor Jake Lucas is the listing agent for Miguel Lopez. Miguel's neighbor, hoping to buy the property for a lower price, offers Jake full commission plus $1,000 under the table if he can get Miguel to agree to the lower deal, which is $8,000 under market value. Jake turns down the neighbor because he has a fiduciary responsibility to Miguel as the listing agent for the home. It is a good thing that Jake is so ethical, because this particular transaction would be illegal and probably cost Jake his license. Old car. You can use an acronym to better remember the fiduciary duties an agent owes their principal. The acronym is OLD CAR, and here is what each letter stands for. O stands for obedience. L stands for loyalty. D stands for disclosure. C stands for confidentiality. A stands for accounting. And R stands for reasonable care. Now, let's discuss each of these 6 fiduciary duties in more detail. Obedience. As an agent, you must obey all legal instructions given by your client and do so in a prompt and efficient manner. Obey is not a term that most people want to hear, but just get past that and think about the needs of your client. On the other hand, if your client asks you to perform an illegal act, then this rule no longer applies. This may seem very straightforward, but it can be murky. For example, it is illegal to discriminate against sellers based on their race or religion. What if a client tells you that they only want to sell their home to white Christians because of the demographics of the neighborhood? You need to explain to your client that your duty is to present all valid offers to them, regardless of race, religion, or any other protected category. Similarly, a seller may ask you to lie about the condition of the property. While you are not expected to be a subject matter expert on architecture, plumbing, or electricity, you cannot lie about material defects that you are aware of or that have been disclosed to you. So, if you are the listing agent and your seller tells you the pipes are cracked, or if you see boxes floating in a flooded basement, you have no choice but to disclose that to a buyer. Of course, the best thing is to advise your client to fix the issue prior to closing. Obedience to a seller versus a buyer is a bit different. The seller's agent has to obey the lawful instruction of the seller and is not required to fulfill requests from the buyer. An exclusive buyer's agent has to obey the lawful instruction of the buyer and is not required to fulfill requests from the seller. Loyalty. Loyalty is one of the fundamental duties an agent owes to the principal. This duty requires a real estate broker to act only in the best interests of the client, excluding even the broker's own interest. The seller's agent is required to do everything in their power to further the interest of the seller. The exclusive buyer's agent is required to do everything possible to further the interests of the buyer. For example, Remy Pascal is a broker representing seller Carl Smith. Remy decides that the property is a great candidate for a quick flip and makes an offer on the home. Immediately after purchasing the home, Remy resells it for a profit. In this case, Remy has not acted loyally in safeguarding Carl's interest above his own. It is not illegal for a broker to make real estate investments, but turning a quick profit on a client you are supposed to represent is considered theft of an opportunity for profit owed to the seller or principal. Disclosure. As an agent, you must tell your client everything that pertains to the transaction that impacts them as part of the agency relationship. This includes facts that impact property value or marketability. It also includes knowledge gained regarding the other party's bargaining position, presenting all offers on the home, information about a buyer's willingness to make a better offer, and intentions to divide or sell the property for a higher profit. Note, the duty of disclosure is separate from a real estate broker's duty to disclose material defects of the property to principals and non-principals. Material defect disclosure is part of a real estate broker's duty to treat all parties to a transaction honestly. Honesty is not part of the agency relationship. The seller's agent has to divulge any known material defects in the property. However, they must not divulge information about traffic problems, poor schools, crime rates, and declining property values in the area, or any other details that make the property less appealing to a buyer. An exclusive buyer's agent must disclose everything they know about the seller, including the motivations to sell and any opportunity for a faster sale. They must tell the buyer anything they find out about traffic problems, poor schools, crime rates, and declining property values in the area. They must tell the buyer anything that might make the area less desirable to a buyer. For example, Pace Walker is the buyer's broker for Ellen Rigby. Pace finds out that crime rates have doubled in the last 5 years and that traffic noise from the highway is clearly audible from within the home. When Ellen asks about property values, Pace not only answers her question, but shares what he knows about crime rates and traffic noise as well. Ellen decides to keep looking, and Pace has fulfilled his duty of disclosure to his client. Confidentiality. You are required to protect your principal's confidences and secrets unless it is unlawful to do so. If you know anything that can compromise your client's bargaining position, you have to keep it to yourself and not share it with the other party to the transaction. Here is how that responsibility is different when you represent a buyer versus a seller. If you represent a seller, you cannot tell a buyer that the seller must sell a property below the listed price. On the other hand, if you represent a buyer, you cannot tell the buyer that your client is willing to pay more than the offer price presented. It is important to note that the fiduciary duty of confidentiality extends even beyond the closing of the transaction. An exception to this rule is if the principal gives the agent permission to disclose certain confidential information. For example, perhaps the principal wants to sell quickly and therefore allows the agent to market the property as a motivated seller. Another exception to the rule is the required disclosure of known material defects that both the listing agent and seller are legally required to reveal. Accounting. Under the duty of accounting, you are obligated to account for, or answer for, any property or money that your client has entrusted to you. This includes money, deeds, and any other documents given to you that relate to real estate transactions in which you represent them. For example, you are the listing agent and the client has given you a deposit for marketing the expenses in the sale of their home. You are expected to deposit this money into a separate account and to be able to account for its use. Reasonable care and diligence. As an agent, you are expected and required to use reasonable care and diligence in pursuing your client's goals. The standard of care assumes that, as a licensed real estate broker, you are a competent professional, knowledgeable in your field. By holding a real estate license, you are considered to have expertise above a non-licensed person. Despite this, a broker is not expected to know details that require a deep understanding of subject matters beyond their licensing requirements. The broker should acknowledge this and refer the principal to the appropriate expert, such as a lawyer, accountants, engineers, or other professionals. The seller's agents are expected to prepare themselves through education to competently represent the seller in all matters. Exclusive buyer's agents are expected to prepare themselves through education as to competently stand up for the buyer at all times. For example, you are the listing agent for Ivan Beaker, who has recently discovered there is a lien on his property that must be resolved prior to listing the property for sale. So, in this case, you refer Ivan to a property attorney and municipal authorities who can help clear the lien quickly. Why fiduciary law is good for business. It might seem like a lot to take in, but it is the fiduciary responsibility that raises client confidence. You can honestly tell them that you are bound by law to represent their interests loyally and fully. You can also explain to the client that this reduces the likelihood they will be taken advantage of by unscrupulous professionals.